allowed by setting aside the CR case number 2189C of 2013. Present application is filed by respondent number 2 in WPC 1292 2017 within bracket since disposed of bracket close, praying for extension of 2 months time to comply with judgment and order dated 29/8/2024 passed by this court. None appears for the applicant and call. Accordingly, list this matter after vacation. Same order, isn't it? Same order, only repeated WPC number will be different. Judgment is also same.
Please, Your Lordship. In this matter, my lord, my instruction is that my lord, the parties are willing to compromise the issue, my lord. So my respondent number 2 is outside the state of Assam. He will return, my lord, then it will be fine.
Okay, it is submitted by Mr.
Yes, Das, my lord.
S. Das,
For PP Das.
learned counsel, that the parties are willing to amicably settle the disputes between them in as much as the matter involves defamation. Accordingly, the learned counsel prays for an adjournment. Prayer stands allowed. List this matter on.
After vacation, man.
Give it date 2009. I think this is the only matter 2009 revision pending.
Yes. Lord, 6th or 7th of January, my lord.
7th of January.
Highly obvious.
Heard Mr. K. Agarwal, learned senior counsel for the assisted by Dean learned counsel. Also heard Mr. Bothakur, learned counsel for the present application is filed both are can be common judgment out of the same thing.
Same.
These two matters are taken up together. We heard somebody on last occasion, Mr. Bothakur, you were not there. In fact, we have completed
Yes,
the
yes,
suppose.
I was there. my lord.
Okay, Mr. Bothakur. The present application under section 397 and 401 of the Code of Criminal Procedure 1973 is filed assailing impugn judgment and order dated 21/7/2003 passed by the learned Chief Judicial Magistrate Kamrup in CR case number 1442 of 1996, convicting the accused petitioners, is not it? Petitioners.
Petitioner number 3.
We'll come to that. Petitioner. Total 5 accused. 5. One.
14 4 are there and 15
Mm,
the employee.
petitioners. Convicting the accused petitioners under section 7/16 of the Prevention of Food Adulteration Act 1954 and sentencing the petitioner accused company is petitioner number
1.
Petitioner number 1 accused company to pay a fine of rupees 1,000 and the other accused persons to undergo rigorous imprisonment of 6 months and to pay a fine of rupees 1,000 each, and in default to undergo rigorous imprisonment for 3 months. The further challenge is impugned judgment and order dated 19/9/2019. These are common judgment, is not it? Both the cases, 19/9 same appeal.
Same.
19/9/2009 passed by the,
Criminal revision petition 2 we have filed.
but judgment is common, sentence appeal is also common. Yes. 19/9 impugned judgment and order dated 19/9/2009 passed by the learned additional session judge, fast track court, within bracket, fast track court, number 1, Kamrup, in criminal appeal number 46 of 2003, whereby dismissing the appeal and upholding and affirming the judgment and order dated 21/7/2003 passed by the learned Chief Judicial Magistrate as recorded herein above. The brief facts leading to filing of this present case can be summarized as follows. Okay. The CR case number 1442 of 1996 was registered against petitioner number 1 against Nestor Nutritions Private Limited, a private limited company, and its directors, namely Satyakam Kashyap, Srimati Bina Kashyap, and Sri Utmal Goswami. What was the name of that chemist? And
So pardon your lordship, in annexure 1, that's the judgment of the this CJM. And annexure 2, that is, it comes from 2 appeal, criminal appeal 45 of 03 and
okay,
46.
you just take it down. I'll correct it. Okay, just
2
take
appeal,
2
annexure
appeals.
2.
Okay,
Yes,
appeal
the-
1 appeal is by the
Company and the directors.
and other is by
Other
the
is
chemist.
Nalin
Chemist,
Chandra
knowledge
Das.
circle, come on, Bina Kashyap, Utpal Goswami, and Nolin Chandra Das, is not it? Or Nolin Chandra.
2,
No,
but
we'll
the
coming. We'll come to this. Just listen to me. Nolin Chandra Das, who was a chemist in the Nestor Nutritions Private Limited. Full stop. The learned trial court, that is Chief Judicial Magistrate Kamrup, on the basis of offence report dated 27/8/1996, filed by one Pradeep Chandra Saikia, Regional Food Inspector, Office of the Joint Director of Health Services, Borpeta. It was alleged in the said of report that offence was committed under section 7 within bracket 1 of the Prevention of Food Adulteration Act 1954, hereinafter referred to as the Act 1954, for selling, storing and manufacturing for sale of ice cream which has been found to be not conformed to the standards wide analysis report of public analyst, Government of Assam, Guwahati, dated 10/7/1996. The learned trial court below issued processes and on appearance of the accused persons, the learned court below explained the particulars of the offence under section 7/16 of the Act 1954 to the accused person, to which the accused person pleaded not guilty and claimed to be tried. During the course of trial, the prosecution examined 2 witnesses, i.e., the regional i.e., the Regional Food Inspector SPW1 and one Lakshmikanta Das, peon of the Office of the Joint Director of Health Services, Borpeta, SPW2, and exhibited as many as 30 documents and 2 parts of sample as material exhibits 1 and 2. After completion of the trial, the accused petitioner and 4 others were examined under section 313 CRPC. Full stop. The defense examined 2 witnesses, that is, 2 witnesses, namely Sri Nolin Chandra Das, within bracket, who is also accused, and the chemist of the company, and another accused, Satyakam Kaisap, who is director of the accused company. Full stop. PW3 exhibited 3 documents as exhibit Ko, Ho, and Go. After completion of the trial, the learned and after completion of the trial and after analysis of the evidence, the learned trial court found the accused guilty of commission of offense under section 7 within bracket 16 of the Act 1954 and sentenced them as recorded herein above. Being aggrieved, the company and its director preferred criminal appeal number 45 of 03 before the learned additional district and session judge within bracket FTC 1 and the appellate court by its judgment and order dated.
This one criminal 45 of 0
I am asking about 45.
45. That
The director.
judgment is common in both the appeals.
The judgment is okay.
Gave the
Preferred an appeal on so and so, so and so. The other accused, namely the analyst, Agra accused, that is the chemist, preferred a separate appeal, which was registered as
46 of 2003.
6 of 2003. The learned session judge, by a common judgment and order dated so and so,
19909.
19909, dismissed both the appeals and upheld the conviction passed by the learned trial court. Being aggrieved, these 2 sets of revision petitions are preferred. Where is the other case? Criminal revision petition 396/2009 is preferred by the company and its director, and criminal revision petition number 449 of 2009 is preferred by the chemist employed in the company. During the pendency of this present petition, the one of the who died?
Petitioner number 3, Beena Kashyap.
One of the director and petitioner in criminal revision petition number 396/2009, namely Beena Kashyap, had expired. Accordingly, the proceedings abated against her. Full stop. Mr. Agarwal, learned senior counsel, has fundamentally urged that the mandate of section 13(2) and the procedure required to be followed thereunder has not at all been followed, inasmuch as and therefore the entire trial has been vitiated for violations of principles of natural justice. According to Mr. Agarwal, though the public analyst report was served upon one of the directors of the company. However, same was served after 2 years of the test result, and therefore such service cannot be treated as a service under law, in as much as by that time by that time there is no scope for the petitioners to even even request for sending the such report to Central Laboratory,
Central Food Laboratory.
Central Pool Laboratory, Central Pool Laboratory. Therefore, the entire proceeding is vitiated. Per contra, Mr. Borthakur, learned counsel for the representing the state, argues that when admittedly the mm, analyst report was served upon the accused company, the mandate of section 13 within bracket 2 was fulfilled, and the company has not raised any objection as regards delayed submission of such report, and therefore at this stage therefore the learned courts has rightly upheld rightly convicted the petitioner. Full stop. This is the case. Before before going further, more particularly in the backdrop of the argument that and in the backdrop of limited argument that the entire trial has been vitiated for non-adherence of procedure under section 13 within bracket 2 of the Act. Let this court first summarize the principle of law in this regard, and as enunciated by the Honorable Apex Court in different pronouncement, and thereafter let this court deal with the factum of the present case. The Honorable Apex Court has consistently been emphasizing the importance of adherence to section 13 within bracket 2 of the Act 1954. There is no quarrel on the point that this section, these provisions of law, this provision of law is intended to ascertain right of accused to challenge, provides the accused, not as a certain, provides a right to the accused to challenge the report of the public analyst by requesting analyzing of food sample by the Central Food Laboratory. Full stop. In the full stop. It has been observed in different pronouncements that failure to comply with section 13 within bracket 2 is a violation of accused right to a fair trial. In the case of Setumal versus State of Madhya Pradesh, reported in so, the Honorable Apex Court held that non-compliance with section 13(2), particularly failure to inform the accused about their right to have the sample reanalyzed by Central Food Laboratory, amounts to a denial of a fair opportunity of defense, and failure to adhere to it would vitiate the trial. In Municipal Corporation of Delhi versus Ghisaram, the Honorable Apex Court reported in so and so, so and so. The Honorable Apex Court held that if the sample deteriorates due to improper shortage or delay in informing the accused about the option under section 13 within bracket 2, the accused right to challenge the public analysis report is compromised, and such non-compliance renders the prosecution's case invalid because it deprives the accused of their statutory right to seek a second opinion. In State of Odisha versus Gauranga Sahu, reported in so and so, so and so, the Honorable Apex Court reiterated the aforesaid principle of law and held that failure to send a copy of the public analysis report to the accused as required under section 13 within bracket 2 renders the trial unfair and vitiates the conviction. It was held in Tulsiram versus State of Madhya Pradesh that right to seek analysis by Central Food Laboratory is a critical procedural safeguard of the accused, and non-compliance results in procedural irregularity leading to acquittal. Okay. In the aforesaid backdrop, this court has perused the prosecution evidence as well as the defense that has been taken by the accused. From the evidence of PW1, what is discernible is that on 6/6/1996, took sample of the ice cream for analysis from the premises of from the factory of the company. On 10/7/1996, public analyst of Government of Assam submitted Exhibit 14 report and opined that the sample collected are not conforms to the standard it is required. Thereafter, on 27/8/1996, offense report, Exhibit 21 offense report was submitted before the subjudicial magistrate, and accordingly, CR case number 1442 within bracket C/96 was registered. There is no dispute that notice was sent by registered port through Exhibit 23 to 28, which is dated, what is the date? We'll see the exhibitor record elsewhere. হেৰি to trial court খুজিলে হ'ব। which was sent on 27/8/1996. Hmm. 27/8/1996. The evidence of DW, the defense took a stand during their cross-examination of the PW1, PWs, as well as during their through their defense witnesses, that the received from the local health authority was received on 15/5/1998, in as much as the analyst report is 10/7/1996. That is, it is their defense case that they have the received the same on 15/5/1998. The defense also exhibited through Exhibit Q the received envelope where the date of receipt is marked and postal seal is there, which shows that it was delivered on 12/5/1998. This DW was thoroughly cross-examined by the prosecution. However, prosecution thoroughly cross-examined by the prosecution. DW DW2 na? Thoroughly cross-examined by the defense and the defense. In his evidence in chief, he has specifically stated that he has received the official envelope on 12/5/1998, and he had exhibited the official envelope where the postal seal of 12/5/1998 was reflected, and he also exhibited the said seal. Full stop. Though defense cross-examined him, however, they have not confronted him with any question as regards validity or correctness of such statement made by the defense in his evidence in shift. What, however, except the fact that except taking a defense that even after receipt of the exhibit Q, that is the official envelope, the complainant has not raised any, has not filed any application within 10 days requesting to send the sample to Central Food Laboratory. Thus, from the aforesaid evidence of prosecution as well as defense, what is discernible is that immediately after deciding that the sample was the public analysis report was sent in the exhibit core envelope and the envelope on envelope on 10/7/1996 as reflected in exhibit 23. The seal put in at the time of delivery in exhibit core, that is the envelope, reflects that it was delivered on 15/5/1998.
Love is exhibit go.
Exhibit go.
Pause the letter.
Pause the letter. Exhibit go. I got your envelope is go, huh? And exhibit go. Such stand of defense that exhibit go was delivered on 12/5/1998 and that it bears a seal dated 12/5/1998 has not been disputed by the prosecution in their cross-examination and not been challenged. Thus, it is established that it was received by the company on 12/5/1998. 12/5/1998. It is also by now well settled that 12/12/1998. 12/1998. The defense took a stand as recorded here in above that even after received the same on 12/5/1998, the accused has not opted for their right to file to request for a re-examination by CFL. Therefore, in the background, this court is to decide whether such non-filing of request within 10 days will go against the accused and they can be convicted only on this ground, and whether it can be accepted that the accused had duly been that the procedure under section 13 within bracket 2 has duly been submitted. Where is the judgment that it is to not only sending, it is to be ensured that it has been served duly? Which judgment? In Girish Bhai Dhyan Bhai Shah versus CC Jani and another, reported in 2009, 15 SCC, page 64. The Honorable Apex Court dealing with a similar situation where the report was received 15 months after the sample, and a sample was of a card. Held that held that in such a situation, it is to be treated that the appellant, that the accused was prevented from applying for the second sample by the time, for the reason that by the time and sample and request can be made for a second sample of second sample to be tested in the Central Food Laboratory. The sample had already deteriorated and was not capable of being analysis. Similar principle was also laid in the case of Ghisaram Supra. Ghisaram Supra. Now coming to the case in hand, there is no dispute that sample of the card, a sample of the what is this? Ice cream. Sample of the ice cream in respect of which the complaint was filed was collected on 6/6/1996. 6/6/1996, and the sample was tested on 27/8/1996, and the report was delivered to the accused company on 15/5/1998. 1998. The subject matter being ice cream, there would be no scope in the present case also to send it for a retesting after 2 years of the sample. Therefore, in the considered opinion of this court, though the accused had a right on 15/5/1998 to seek for retesting of sample in the sample food laboratories, but such right has become a futile right to be exercised in view of lapse of time. It is also by now well settled that the right to seek a sample tested and a central food laboratory being a valuable right, the prosecution is to ascertain that such report is duly served upon the accused, so that the accused can opt to exercise its right. Accused can exercise its rights. Municipal systems of DDU. In Municipal Corporation of Delhi, within bracket Supra, it was also held that right of the accused to get sample examined by the director of sample laboratories shall be vitiated vitiated if the report is served the report is served belatedly and the meantime sample becoming decomposed and resulting in impossibility of a second analysis. Similar is the case in hand. In the considered opinion of this court, the prosecution had its responsibility to ascertain that the report is served within a period of reasonable time. Though the legislature has not prescribed any reasonable, the registrar has not prescribed any time. What is the judgment, Bothakur? Reasonableness on that day?
Yes.
Reasonable delay. Though the prosecution, though the legislature in its wisdom has not prescribed any period within which such report is to be submitted, but looking into the scheme of section 13, more particularly, when a right is created under 13(2), the aforesaid period that the report should be submitted within a reasonable period of time. That reasonable period of time from that other judgments. In view of the aforesaid, this court is of the view that delayed service of notice has vitiated the right of the petitioner to do and so and so, so and so. Accordingly, judgments are set aside, and this vital part has been ignored by both the learned courts below and ignored the evidence of DW1. তাতে এটা কথাত লিখিব evidence যে লিখিছিলো ওপৰত লিখিব. The fact also remains that it is somewhere it will be above. The facts also remove that the accused person in their statement recorded under section 313 CRPC had specifically took a stand that they have received the more particularly the DW1 took a stand that though they had received the public analyst report, but they received the same on 15/5/1998. DW2. I'll correct that. DW2, 15/5/1992. That's the in the totality of them, first part of it. Allowed. But all these judgments after vacation only will be uploaded. Not possible to correct all these judgments during this week. Common judgment. এইখনো লাগিব তাতে, এইখনো লাগিব. What is the name of that person? Mr. Bothakur? Jahidul Islam. Just note it down, Jahidul Islam. That is UAPA Act.
This, your lordship, I was appointed as an yes, your lordship.
What is the case here?
Yes, your lordship. Yes,
Here also 13(2).
lordship 13(2) and also lack of your lordship independent witness at the time of collection. These are the only two grounds. But there is one.
Forget about that independent test for the time being.
13(2) also, your lordship. It is a admitted position is that has not been provided to me, your lordship. Collection of the sample and report of the public analyst. Your
Report was even not served.
report was not served, but your lordship, after institution of the proceeding, your lordship, report was served by the court, and then your lordship, we applied for your lordship sending it to CFL, and CFL, your lordship,
Affirmed.
confirmed it. But
Mm.
only thing, your lordship, there is a slight difference between the report of the public analyst here and the CFL, your lordship. And that my humble submission will be, your lordship, that delay, your lordship, in sending the report to the present
What was the
petitioner,
matter here? Food,
Haldi, your lordship.
powdered haldi.
Otherwise, your lordship, and secondly, on that point, your lordship, that independent witness, my ground is this, I have found in the petition, your lordship, that they have taken that point also, your lordship, and from the records, I have found that, your lordship, there is a specific plea so far as the present petitioners are petitioners are concerned. They have said that suggestion was made that you have to that the sample was not collected from that particular. If that suggestion is there, probably presence of independent witness, and from the cross examination, it is also found that apart from the PW1, the person, officer, food inspector, he has submitted before the court, that learned court below, that so far as he tried to bring some independent witness who were customers of that, but he could not find. But in the cross examination, he also accepted that there are other shopkeepers there in and around the place, Your Lordship. That
But he made an attempt.
he made an attempt
He-
only for the customers, not for the others, shopkeepers and others.
Hmm.
In
So-
absence, and the PW2, who is the peon who went along with this particular inspector, PW1, he had submitted that his initial statement is that both of us has gone there to unearth whether there is any adulteration or not to go. And that being the position, probably the absence of independent witness.
Will it be so fatal at this stage?
If your lordship, the
See, law is this, that it is preferable. It
To
should
have.
be to have the sanctity of the collection of sample or sanctity of the seizure. It is very important. But when an attempt is made, but he could not, then it will not vitiate the entire
that is
proceeding.
there.
And
that-
there
that-
are materials to suggest that he took an admitted. Now, whether this attempt is a sufficient attempt or not, can we go at this stage in a
Your
revision?
lordship may not, but your lordship, had it been not his case, that there are other shopkeepers also,
Hmm.
and why he had not called them, that explanation is not there, your lordship. He has talked about in his cross that only about
And you have opted your right under 10 also.
under 10,
Within under 13(2) also.
13(2),
We'll take up this matter after vacation.
or your lordship can do one thing, your lordship.
That
At the
part.
end, that part, your lordship, that judgment is also there.
Yeah.
We can take advantage of the new act.
Mm.
That judgment is there. Your lordship may have already.
I have
passed,
already dictated past and
and
judgment.
that judgment is.
This case, I do not think petitioner, I have requested twice, thrice. They are seeking adjournment only.
Your lordships can, on the basis of this, your lords, LCAM.
That one judgment, Mr. P. Mohanta's case, he has conceded, so we have passed the judgment in that. No, Mr. A young guy. His opening argument was that I am insisting on this. So I have passed a detailed judgment, how this has say law is changed, when it can be done. So that you can cover this.
Yes, your lordship, and that judgment also says, your lordship. And two other judgments is, your lordship, this is 2000, no, sorry, Trilok Nathapur. Trilok Chand, your lordship. This is 2020. This also says, your lordship, that it can be altered to fine.
Already uploaded. Okay, pass, Harry. 500 টাকা করে দাও।
Rather than keeping it the matter pending.
The petitioners are also
And
not
in fact,
interested,
your
twice,
lordship
thrice listed,
your
calling
lordship will
the
kindly
lawyer, the junior was there, yes, you were there, no, you, huh?
Some other lawyer.
What is this, we had to appoint amicus, we have given you time, what is this? Aspiro will never come. Disposed of.
If he had not exercised that 13(2), he would have been a,
Very good case.
he has.
Otherwise,
exercised
it will lead some, but petitioners is not interested, let him give the relief in a different way. We are not sending him to jail, that's all.
that. Obliged.
Kothari. Exactly the same.
Obliged.
Yes, Mr. Bora now.
That's the 13(2).
Hmm. What is the factum? You have not been served.
That is, they have only proved that the peon book, my lord. They have said that the 13(2) notice been served.
Huh.
But the peon book, it was in a photocopy. That was the defense case, my
So
lord.
your whole case is that it should be not only sending, it must be ascertained that it is a valuable right. That is what we have dictated the last order.
That is the only point involved. There's one more other point also. very, otherwise that is, that point is otherwise very interesting point. But if whether Lordship will go into that, very, otherwise there is no judgment to that effect, but
What
very
is that?
interesting aspect is
What
that.
is that?
That is that
We'd
the-
like to go because
Yeah.
we are doing some repeated works,
Okay,
but
then-
not before vacation.
Then, my lord, that's what,
If you are interested to argue immediately after vacation, a new point, I would like to go to it.
otherwise Lordship, when that the whole two-person being, husband and wife both are.
So
convicted
that we
of
may,
this.
we may equate that is a different, but what is the other point? Tell us.
Other point is
See,
that,
I am sitting here taking what not 125 proceeding,
yes,
145. Sometimes
Then-
you need something for your brain too, na?
then the Lordship kindly see.
What is the second issue?
Yes,
Tell
the
us. Then
second
we'll
issue
give
is-
a chance to Borthakur also. He will come prepared.
But that's
Or otherwise 13 we have
Yes.
already, that's why I have dictated the whole
Yes,
part
yes.
that it will help. We'll either go this side or that side. This is the principle of law depending upon the facts.
Because indeed regarding the 13.2,
Mm.
the BW1,
Mm.
he himself has admitted,
Mm.
it is the exhibit number 25,
Mm.
where the Peon book, my lord.
Okay.
It is a fact that the exhibit 25 is a Xerox copy of a particular page of Peon book and not brought me today,
Originally is not brought.
not brought me today. That is the in the cross.
So proof is not there.
Book is not there. That is the 13.2 service of the,
Is not there.
have not been proved beyond reasonable doubt, my lord.
And what is the second point?
Second point, my lord, this is the haldi powder, turmeric powder.
Mm.
It was then when it was tested, my lord, they have found additional, my lord, rice powder in it, my lord.
Mm.
Now, rice powder, it's a primary food, another primary food. Now, the lordship kindly take up the old book, my lord.
Mm.
So kindly see what is the
Food adulteration.
food adulteration, my lord? আগৰ কিতাপখন দিব লাগিব। What is the meaning of adulteration, my lord? Section 2. M, my lord.
Just a minute. Section
2M. Small
2
Small m, my lord.
L M. If
adulterated, my lord. Yes. So what is adulteration? So I have been charged for this adulteration, my lord.
this is a definition, is that it?
Yes, my lord. This is definition.
Adulteration means
Yes, ma'am.
any material A, B, C, D, E, F, G, H, I, M.
M.
If the quality or purity of
Quality or purity of the articles
Hmm.
falls below the prescribed. Here there is no, it is not, does not, it not fall beyond the prescribed, my lord. It is only the addition, or it's a constitute are present in the quantities not within the prescribed limit.
Hmm.
Not the case here, or variability, but which does not render to injurious to health. When the variables are lesser quantity than the first part. Now, second part,
provided.
provided that where the quantity or purity of article being primary food
Hmm.
has fallen below the prescribed standard, or its constituents are present in the quantities not within the prescribed limits of variability, in either case, solely due to the natural causes and beyond the control of human agency, then the such article shall not be deemed to be adulterated within the meaning of this subclause. This is the now explanation. Where two or more articles of primary food are mixed together
Hmm.
and the resultant are of food, number A, is stored, sold, and distributed under the name which denotes the ingredient thereof, and now N, B is not injurious to health, then such resultant articles shall not be deemed to have been adulterated within the meaning of the clause. So if there are two primary food, my lord, here, in my case, turmeric was mixed along with the rice.
No, how do you say where two or more articles of primary food are mixed together
Yes,
and resultant article of food
yes,
is stored,
yes.
sold or distributed under a name
Name which denotes
which
the
denotes
ingredient
the
thereof.
ingredients thereof. So ingredients thereof meaning by
turmeric.
will it declare both turmeric and rice?
My contention is not the we have declared that turmeric, but there's a mixed with rice also. Resultant article of food.
Now, how do you interpret under a name which denotes the ingredient thereof? So can it be said that it denotes the name of haldi and two things?
My cases, it was the,
It's a haldi.
it's a haldi, their case is haldi.
Haldi mixed
But
with rice.
mix is
Now it says where two or more articles of primary food are mixed. Here two primary foods, one is haldi and one is rice is
Right.
mixed. Are mixed together and the resultant article food. There is a resultant article
yes,
food
resultant article food.
is stored, sold, distributed. For these are not important. Under a name which denotes
Note the
the
ingredients
ingredients
thereof.
thereof, meaning ingredients will come both the primary food or one.
My contention is the
Ingredients will be ingredients, both two
but
ingredients.
the otherwise,
Mm.
what is the necessity of the second article to be mixed with? And the resultant, there's no need, resultant article of turmeric and rice, my lord. It either has to be rice powder or turmeric.
But you will have to have importance on and also. And
yes.
will have an importance.
that
Is
why
not
and
injurious to health.
Yes.
Because otherwise, anything injurious to health
it mixed with the.
and
proposed-
anything injurious to health is an adulterated or it's not for human consumption. Here it says you mix two items declared to be according to you declared to be one, and it is not. There is no
Injurious.
report that this is not injurious. Suppose you mix with some khar and tenga, as we
Then,
say,
yes, then it is.
then it will be
to health.
injurious.
Then it falls under adulteration. my lord. That is one part.
This will require some brainstorming. Two way, either to close it 13-2
And the
and or to go anything. Have you got anything on this interpretation anywhere?
No, my lord, there is a one judgment of our High Court
Ah.
similar to this line also. But
What-
not very explanation was not much.
What it says?
It says that it's not adulteration. They also turmeric,
Mm.
but not, that explanation is not, I have not found. Yeah, I have what I have interpreted before. But ultimately, it says that it was also turmeric and the rice. And without going into the much details in that aspect, my lord.
But will it not require declaration that it is mixed with turmeric? Or then it will become a different food, rice and turmeric.
But that is one.
Yes, but Thakur, which side?
Or otherwise, my lord, and also, my lord, that judgment is also there, my lord. The conviction, my lord, only fine. Also serve the purpose, my lord.
The shortest way.
Shortest.
Shortest way is a converting to the fine.
Yes.
That's all. Dispose of.
Well.
In some other good days, we'll deal with it, not before vacation. Dispose of.
Yes, my lord.
500, that is Mr. Bora. The judgments are there. I have already dealt in one case and elaborately dealt how and when.
Because otherwise 13-2 also, my lord.
Ah. That matter after vacation. That oh, this is at that point of time it was permissible, is not it? No, not.
Yes, well,
Hmm?
that is a.
Oh, that is probation.
Yes, well, probation officer. Finding everything, well, against the accused, ultimately, well, without any reason.
Offense was serious after vacation. After Bihu, we'll apply our mind. Mr. Bora, in 2018, we may not go today. Because other will go up to 2017. Your is in 2018. Give a date. See, so many disposals we'll have to correct, and before vacation we'll have to upload everything. And PP has requested us to adjourn beyond 17. 18, from 18 they have requested us to adjourn all these matters.
Then 7 and 8.
7 and 8. Okay, 7 and 8. Mr. Bora is there. Mr. Day was here. Where is he? Okay, we'll take it. Give a date. You have a ask your junior. Have a consent from Mr. Day and convenient day. Give it to Mosumi. Okay, Mr. Bora, tell your junior the date.
8, my lord.
Eight in item 8. Interim is to continue until further orders.
Item number 5, my lord, as per my instruction, in this case, my lord, long back in the year 2015, final report, my lord, submitted in this case.
Yes,
Miss Jain Sahewala had to leave the court due to sudden
that's fine. But he has said
Final
that
report, no case.
you have challenged a FIR. Final report has been submitted. Matter ends there. Influx was. The present application is filed under section 482 of the Code of Criminal Procedure, assailing for quashment of Gorsuk PS case number 397/2015, registered under section 120B/420 IPC. Mr. Borthakur, on instruction from the concerned IO, submits that the investigation has in the meantime completed and the IO has submitted final FF, na?
FR, my lord, final report.
Final report being
Being number 313/2015, dated 31/10/2015.
in view of the aforesaid, nothing survives in this petition. Accordingly, same stands closed.
No, yes, no.
May please, Lordship.
Yes, what is this?
The other day, Lordship heard the matter on 4th of December.
What was that?
The Lordship proceeding under POXO, Lordship.
Oh, that
And Lordship.
after vacation.
Obliged.
Yes, Mr.
Madam, this is a question, but there is another application, my lord, filed with a similar matter.
Hmm.
That, my lord, that is, this order is there, one. Same issue, my lord. I pray that, my lord, this matter may be listed along with that matter, my lord.
This is
also a-
2024.
Yes, the 2010 FIR, my lord.
Hmm.
Now the police's investigation, my lord. So they came before the court, my lord. Issue is same, my lord. That fake pharmacist.
Same affair.
Same, not same FIR, but contents are same, my lord. The
No,
fake
if
pharmacist.
then will 24
My
will
lord,
not
this
take up.
case investigation state, my lord, long back on 21/6/2018.
Ah.
And there are, my lord, lots of writ petition. I have also received the case. I will have to go through. In
Okay, you
detail.
go to it. Mr. Yeah, this relates to a different FIR.
Different FIR. Yes,
Contents may be different. So all FIRs we cannot club. It different affairs in relation to and different entity.
no, my lord, the question is that the issue is same, my lord.
Maybe let us decide this issue here. You assist us. He wants some time. Then we'll proceed. 24 we cannot bring in.
Yes.
Okay, Mr. Borthakur, learned counsel for the learned additional public prosecutor submits that he needs some time to prepare this matter. Accordingly, prayer stands adjourned.
Yes.
Prayers stands allowed and be listed after due vacation.
Yes.
After due vacation, give a
The
date.
date, my lord.
Yes, Mr. Bora and Day, your item number 7.
Starting 7. I don't think I have a case, my lord.
You don't think you have a case?
My lord, it can be passed within a few seconds, my lord.
What is this? Please on item number 7. Item 7.
Yes. What is tomorrow?
It was basically a proceeding under 138.
Ah.
My lord. After the period, my lord, they filed an application.
For condonation.
Petition under cognizance was taken under 420.
420.
Ah.
But in fact, while after we received the notice, we paid 1 lakh. Thereafter, another amount was paid. There was a
But in the complaint petition, my lord,
This-
there is no avertment that there's a initial deception on
So
their
now
part.
tell me, Mr. Bora, what is the law as on date? Can under 138, a person can also be prosecuted under 420 and 406?
If there is an avertment to the effect
If,
that
if there is
his
an avertment.
intention, with an intention, he has given a check,
Mm.
knowing that it will going to bounce,
Mm.
and thereby he has taken some
Mm.
subsequently
Mm.
advantage from
Mm.
the other side. Then there will be cheating, but that ingredient has to be there.
No, if ingredients is there prima facie in the complaint itself under 138, what is the law as on date? Is it to be a separate or in the simultaneous or in the same case?
My contention, it may be in the same place.
In some cases, you therefore have adjourned this matter and fix it after
There-
vacation.
There is Supreme
There
Court
are
one-
some judgment which
Sup-
says that it should be,
even
it
there-
says
there-
some warrant proceeding, this proceeding,
yes.
so it
But
can,
One is the summary proceeding,
Ah.
otherwise the 138 is basically summary.
Summary
then
proceeding.
Follow summons.
presumption is something different, 406 is something different. So therefore, at best, it can be a simultaneous trial, not the common trial.
But
Is it
there-
the law?
There's one judgment also that the both can go together also.
Can you provide this judgment
Yes.
through
So that's why I'm saying, my lord,
third? Mr.
only
Dave?
thing, my lord, that my vehement objection like PP has used to give, that may be recorded. I've learned it from all the PPs. Vehement objection may be recorded, my.
That will have to record.
Yes.
In earlier, it was so far relating to condonation of delay. My Lord Justice Agarwal, once I said, my Lord, my objection may be registered, but I am not opposing. So he recorded. So has vehemently opposed condonation of delay.
problem is with the Milord CC. Earlier, Milord, it was quite different.
That is of course, I will not comment, but I myself get disturbed when I see in the screen. So in my court, I don't see myself. When you see discussing with the lawyers, it gets disturbed. Heard Mr. Day, learned counsel for the petitioner. The present and also Mr. Bora, learned senior counsel, assisted by Swensu for the respondents. The present application is filed under section 482 of the Code of Criminal Procedure 1973, assailing an order dated 3/11/2016 passed by the learned judicial magistrate first class Kamrup within bracket M in CR case number 1999C/2015, whereby cognizance of offense under section 420 IPC was taken and process was issued against the petitioner. The aforesaid complaint was lodged under section 200 CRPC, alleging commission of offense under section 420/506 IPC.
And my lord, one point is, my lord, the company was not made a party, my lord. That's one of the vital issue, my lord. Sorry.
It's the hardest case.
Onita Hada's case, only the care manager and the project manager, they were made accused in the complaint without making the.
The accused are admittedly manager, project manager, is not it? Manager, project manager, and project manager of one.
Manager project
Hmm.
manager.
of Messrs. VALEHCHA Engineering Limited. Full stop. The primary allegation is against the company. This is Star Cement or what?
I'm for this Star Cement, man.
At least before any other bench without me.
Sorry.
Star
Cement-
Cement.
cement
Ah.
beneficiary.
That's Star Cement.
Yes, yes.
At least before any other. See, I don't have any relation, but one of my closest friend works in a high position there. And he meets now and then me. Star Cement, I'll not take up. At least before any other bench without.
I tried to help him a lot, man. What to do?
Yeah.
That is the destiny.
Destiny.
Obliged.
Yes.
Subsequently, my lord, complaint already been cross-examined. That has not been recorded. Necessary to follow.
What is the case? Please tell us first.
My lord, this is the bribe amount, money regarding providing a job to
Ah.
the complainant son.
Ah.
But when failed, the case has been made up. That
Up for
was the complainant, my lord.
after vacation.
The meantime, up to date LCR call for. Subsequently, there is a development.
What is that? Bring the certificate copies.
But proceeding was stayed, if I'm not wrong. No, proceeding stay. Proceeding already stayed.
Then
And but prior to stay,
you
lordship.
bring on, take certificate copies. That's all.
Lordship. My lord. After
After vacation, after Bihu. Let us complete the pending works first.
hello.
Yes.
My lord, I stand on behalf of Senior Counsel Z Kamar. He's currently out of station. If it's me, then I would like to try my luck.
Lordship, one,
Let him be busy somewhere else, not here. We will not adjourn for on behalf of Jet Kamar. What is the issue?
My lord, an FIR has been lodged against
He is
me.
the senior advocate. He must give importance to High Court. Where is he? Gwalpara,
Mm,
Bongaigaon, CBI.
I do not know the matter. but-
No, you must know. When you may have made an
May I present, my lord?
Lordship, where 161 statement is not there.
okay. How do you get that? Scan copies of the case diary. The search sheet is filed.
Charge sheet file.
My lord, charge sheet has been filed. There is an error apparent on the in the medical.
Then you are ready. What is the error apparent? What is the case?
My lord, the case is such that I went to my ancestral property in Samoguri, Nagaon, just before Bihu. Upon reaching there, we had a dispute with my cousin, in which it turned heated. After the consequence of this heated argument was that my driver got beaten up. I admitted him to the hospital. I lodged an FIR against respondent number 2.
Mm.
I lodged the FIR on 26/1/2017.
On the prayer of learned counsel for the petitioner, matter stands adjourned and be listed. Give a date. There is stay.
Yes, there is a
Is a give a date.
obliged.
Yes, Mr. Bora.
Well, this matter is pertaining to Arunachal bench, but at the permission given by the Honorable Justice Miller, the matter has been before this principal because of the fact that the lawyers has do not want to take up this. There is a resolution, Miller. I will just place the matter Miller, and it's a peculiar case whereby Miller, your lordship will find I have challenged the entire proceeding of a complaint cases, Miller. The petitioner has gone to the court of Alu, Miller, where he has to adduce a defense witnesses, Miller. And as per the allegations, Miller, if your lordship will find, that is at page 12, Miller, Annexure B, a lawyer, Miller, a lady lawyer has lodged in complaint. Well, kindly see, this is a, Your Lordship, I'll go through. Page 12, Your Lordship will kindly see two paragraphs, my lord. The victim complainant is a registered practicing advocate. Today on dated so and so during the court hours, when the victim complainant was discussing her cases with our client, suddenly so and so,
Anything, and this is an FIR.
not a fact, complaint case, my lord. What has happened on the basis of the complaint, my lord? On that day itself, without issuing summon, my lord, I have been arrested and put behind the jar. Put behind the bar, my lord. Your Lordship will kindly see.
No, that is fine. But what is the presence? Now it has been registered as complaint case.
Complaint case, my lord.
Complaint case. 200 statement recorded.
My lord, here
No
what,
process issued.
nothing, my lord. Kindly see, that is why
That's
I,
why you are,
I am for the respondent.
Yes.
The complainant.
Your
Honor, after the case has been stayed by this honorable court, the accused, he was granted bail. Thereafter, he have appeared and I will take your honor to annexure G, page number 24. There was a statement order passed by the presiding officer, the chief judicial magistrate. May I read this order?
Yes. Please tell us.
that's, I want.
Tell us.
Your Honor, in this case, the complainant was examined. It has been said today the present case is fixed for examination of witness before the charge. The complaint along with 4 witnesses are present and they are examined as PW1 to PW5 in the present case. And the cross examinations are reserved by the learned counsel for the accused. Seen petition so and so filed by the learned counsel of the
What
complainant.
is the cross examination at this stage? Where is the order of cognizance?
Nothing. Actually, Your Honor,
Please,
Yes.
this matter after vacation, interim order pass earlier shall continue until further orders.
This record, because the High Court has ordered for a inquiry, my lord, after going through, my lord. Now, this order has been, afterthought, the order has been passed. What has happened? That the
We
lawyer-
will examine this matter
Ah,
after vacation.
My lord,
a report was also called from the registry itself.
Anything is there? We'll see after vacation.
my lord.
This is not the way how a criminal case is proceeded. As simple as that.
One paragraph. Say that.
Maybe one paragraph,
What
maybe
will it be, my
verbal,
lord? What has
but there is
happened?
a procedure.
Warrant has
That
been
is to
issued.
be registered, 200 inquiries to be, 202 inquiries to be made. There must be a satisfaction, then process is to be issued.
My lord, we are not able to find what has happened in this case.
No, I have seen that
But
after vacation.
200, my lord, nothing, my lord, arrested by the
seen that.
police, send it so and so. When the matter has been brought to the notice of the High Court, my lord, when the High Court on the first day granted bail, on 12, he writes that on that day, so and so has been given, bail has not been, could not been given. Like, if anything has been
What is
written
the
there.
question of cross-examination on day one? When you do one mistake, you do the second mistake. When you want to tell a lie, then you did tell the second lie.
Second
And
line,
you cannot get out of it. Yes,
What-
we'll
what-
see. We'll see if necessary, we'll take administrative action. Yes.
I'm-
Much obliged.
Yes, what is this, Bhattakur?
Convicted under section 325,
325
325.
for
Oh, my lord. Five years, my lord.
this is
RI for-
appeal.
RI for 5 years.
It's in revision.
Yes, sir.
RA for 5 years.
5 years.
None appears for the petitioner on call. The present revision is filed assailing judgment dated 14/7/2010 passed by the learned Assistant Session Judge Borpeta in Sessions case number 215/2006, whereby the petitioner was convicted and sentenced to undergo rigorous imprisonment for 5 years and fine of rupees 2,000 and in default of payment of fine to default of fine, another 3 months of simple imprisonment under section 325 IPC. The further challenge is an order dated 29/2/2012 passed by learned additional session judge Borpeta in criminal appeal number 17 of 2010, whereby the appeal was dismissed and the judgment and conviction passed by the learned trial court was upheld. However, reducing the sentence to RI for 2 years and with fine of rupees 1,000. Considering that none appears for the petitioner and that the judgment that the challenge is against conviction, this court is deemed it fit to appoint so and so as amicus to assist this court full stop registry to furnish the connected papers to the learned amicus and thereafter list this matter for hearing on given date after vacation. After Bihu vacation. 28th of January. That's all?
Yes.